Hello! This very brief video tutorial will give you the basics of what you need to know with respect to Canadian constitutional law. The most important constitutional law document is the Constitution Act 1867. It essentially constrains and controls how the various branches of government exercise their powers. Now what the Constitution essentially does is it divides powers, or what we call lawmaking jurisdiction, amongst the federal and provincial governments. The Constitution also contains the Charter of Rights and Freedoms, which was actually added to the Constitution in 1982. This document essentially guarantees your fundamental rights and freedoms from incursions from the various governments. Now, you should note that the Americans have had their constitutional rights enshrined in 1776, so they have well over 200 years experience in deciding and having their courts make decisions on how rights are violated and infringed by the government. In Canada, our courts have only done that since 1982. Now, why is constitutional law important for a business? Well, as I said, the Constitution divides lawmaking power between the provinces and the federal governments. So I'm assuming that as a business owner or someone involved in business, you want to determine whether or not a provincial law would apply to your business, or whether a federal law would apply to your business, or whether both. Okay? Now, I'll give you an example. Let's just say you're a television production company involved in the making of educational television programs. Well, the Canadian Constitution says that the provinces are responsible for educational matters, while the federal government is responsible for telecommunications or television matters. So right there's sort of like a gray area, and it might be possible that you might need to seek legal advice to determine what laws you are bound by. Okay? Now, with respect to the Canadian Charter of Rights and Freedoms, I think it's important to note that the Canadian Charter of Rights and Freedom only applies to a fundamental right or freedom violated by a government. Okay? It has no application if that right has been violated by a private person, a private company, or a private individual. Some students confuse the Provincial Human Rights Code, which regulates private, non-government institutions and individuals, with the Canadian Charter of Rights and Freedoms. For example, if the federal government restricts applicants to a job to a sole sex, for example, they say only a male can apply for this job or only a female can apply for this job, the Charter of Rights could be the basis of a complaint with respect to the right to be equal before the law. Now, if a private company decides to do the same thing, the basis of any complaint would be the Provincial Human Rights Code. Okay? When someone accuses the government of violating the Canadian Charter of Rights and Freedoms, the complainant must prove that the right or freedom was limited or restricted. At that point in court, it becomes the government's responsibility to prove that that limit or restriction was justifiable in accordance with Section 1 of the Charter of Rights and Freedoms. Okay? So Section 1 is actually a balancing test that the courts use. Section 1 of the Charter essentially states that the rights and freedoms within it are subject only to such reasonable limits prescribed by law as can be demonstrably justified in a free and democratic society. So if the government cannot justify in court that the limit is reasonable and is prescribed by law in a free and democratic society, then the court will rule that the government itself has violated that fundamental right or freedom. Now, often such a ruling will involve the need to amend the law or change a government practice. Thank you very much.